Court of India has just passed its verdict refusing the restoration of 4G internet in Kashmir. The court has held that there needs to be a balance between human rights and national security. But while the judgment is saying that a balance needs to be struck, the court has clearly prioritized one over the other. The court has also set up a special committee which is to be headed by the Secretary of India's Ministry of Home Affairs to decide if the orders passed by the same ministry are appropriate or not. This serves to be an ironic reminder by the Supreme Court of India that the doctrine of separation of powers is not really codified in the Constitution of India. Directive principles are non-enforceable, not justiciable anyway. It is this committee that will then examine the requirement of internet in Kashmir as well as all concerns raised by the petitioners. It is relevant to add here that the petitioners had argued that 4G internet speeds were essential for healthcare, business activity, work from home, online classes of students. And they even highlighted that while today there are over 700 cases of COVID in Kashmir, when this petition had been filed, there were only 33 cases of COVID in Kashmir. And that doctors require 4G internet for online consultation of their patients. However, in response to these concerns, the Solicitor General of India, Tushar Mehta, has blithely commented that there is no information, there's no data available on anyone who has died because of a lack of access to internet. These restrictions are inconsistent with the fundamental norms of necessity and proportionality. The judgment implies that the Supreme Court of India has abdicated its responsibility to decide, to adjudicate whether the orders of the Ministry of Home Affairs are excessive, arbitrary or unconstitutional. Even earlier in January, the Supreme Court of India took 5 months to decide on the lockdown in Kashmir. And even after 5 months, there was no order passed, there was no finding on the constitutionality of those restrictions. In today's judgment as well, the court has not made any substantive findings, so there should not be a binding effect of this order. However, the court's refusal to pass any directions against the MHA emboldens the Ministry of Home Affairs, and it carries tremendous persuasive value as well. In conclusion, I would just like to give your viewers 2 reminders. The first is for the Government of India and the second is for the Supreme Court of India. The reckless action of the Government of India is in violation of Article 25 of the Universal Declaration of Human Rights. And in 1979, India ratified the International Covenant on Civil and Political Rights, which guarantees the rights of freedom of expression. In 2016, at the 32nd session of the United Nations General Assembly, a resolution was passed condemning the consistent and incessant shutdowns of communication and internet by the Indian government. Even in the last few months, various UN representatives have made statements reminding the Indian government that these shutdowns are a violation of Article 19 of the Universal Declaration of Human Rights. The second is a reminder to the Supreme Court of India. The structure of the internet is too vast to be defined merely as a tool of communication. It affects every possible activity, many of which are not communicative in the human sense of communication. In this light, these restrictions on communication must be viewed as an arbitrary, unconstitutional and fundamental violation of the rights of Kashmiris affected. The final arbiter of all issues in India is the Supreme Court of India, but it seems relevant to remind the court that national interest as defined by a government in power is not a ground that meets the test of reasonable restrictions on fundamental rights and basic human rights. The consistent inability of the court to do its only job is an abdication of the responsibility of the court.